The President. The trial chamber declares the continuing of the hearing. First, the chamber instructs the graphiers to work on the list of those who present during today's hearing. The graphier, Your Honor, Mr. President, the list of those participants today has been checked. Today there are civil party lawyer who is present, Mr. Philip Cannon. Thank you. The President. The graphier, please make a record of the list of those who present in today's hearing in order to make it accurate in the transcript. Next. The trial chamber will respond to the pending issues raised by the civil parties on the 31st of March and the 1st April 2009. The chamber wishes to answer briefly to various requests for clarification presented by the parties during the hearing held last week. Thereafter, the trial chamber will issue two decisions. Firstly, the chamber wishes to reiterate its understanding that during his response to the opening statement by the co-prosecutors, the defense lawyer did not make any formal submission on the legality of the proceedings or the jurisdiction of this court. Secondly, the chamber wishes to clarify the issue of the scheduling of the trial, the questioning of the accused, witnesses and experts, as well as the hearing of civil parties. The trial chamber wishes to reiterate the indication provided in its direction on the scheduling of the trial, dated 20 March 2009, that it will question the accused first and then in turn the relevant civil parties, witnesses and experts in the order it considers useful. The trial chamber plans to follow the sequence of facts presented in the closing order. The parties will be informed of the facts scheduled for any given trial day approximately 2 weeks in advance. On any given fact, the chamber will first hear the accused person, then give the floor to the parties to ask questions to the accused. Thereafter, the chamber will call civil parties, witnesses and experts pertaining to that specific fact. These will first be heard by the chamber, then the floor will be given to the parties. As a rule of the ECCC internal rules, the accused should only be confronted with written witness statements after the witnesses have been heard, provided that these witnesses can be brought to court. As a rule of the ECCC internal rules, the trial chamber will endeavor to call each witness only once. However, for witnesses who are relevant to more than one fact, the trial chamber will decide on a case-by-case basis whether they should be heard at one time with regards to all facts, or whether they will be recalled. Afterwards, any additional evidence pertaining to this fact will be presented, i.e., any additional documents in the case file pertaining to this fact will be read or summarized in accordance with the provisions of Rule 87.2. The chamber wishes to clarify that cross-examination is a manner of questioning typical of common law systems. Proceedings before this court are governed by a primarily civil law system, Cross-examination as a manner of questioning is not suitable for civil law system. With regards to the scheduling of the hearing of civil parties at trial, the trial chamber will hear those civil parties who have knowledge of specific facts at the time when the chamber deals with these facts. All other civil parties will be heard at the same time towards the end of the trial proceeding. It is currently not possible to foresee the exact scheduling of the hearing of these civil parties. The chamber will provide a scheduling of the hearing of civil parties, witnesses and experts 2 weeks in advance. However, where civil parties, witnesses or experts live abroad, the chamber will endeavor to provide a schedule at least 4 weeks in advance. It will be helpful for the scheduling of civil parties, witnesses and experts who live abroad if the trial chamber could be informed as soon as possible of any dates when they are available or unavailable. Thirdly, Mr. Hong Kam Soon, the civil party lawyer for groups 2 and 4, indicated that the pseudonyms used in the closing order do not correspond to those used by the trial chamber. The chamber wishes to clarify that during the trial, the pseudonym assigned by the trial chamber for references to protected witnesses or civil parties will be used. The difference in the use of the pseudonyms raised by the civil parties lawyers was due to the fact that the public version of the closing order containing pseudonyms assigned by the co-investigating judges was read out in court. Finally, the trial chamber issues the following 2 decisions. Firstly, the request by the civil party lawyer for Group 2 to allow them to comment on the accused response to the opening statement by the co-prosecutor is rejected. The reason is that Rule 89b(2), which foresee a response by the accused to the opening statements by the co-prosecutors, does not foresee any response by the civil parties. Contrary to the submissions made by the civil party lawyer, the fact that the accused response to the opening statement is foreseen by the rules. Second decision. A. The request by the civil parties lawyers to make submissions with regards to the defense request to release the accused for the duration of the trial, as well as the document filed by the civil parties lawyers for Group 3 on the 1st April 2009, document number E39, containing submissions in response to the defense request are rejected. Reasoning. Rule 82(3) does not foresee the possibility for such intervention. This rule, which deviates from Cambodian law, is the result of a conscious decision by the ECCC plenary, shaping civil parties' participation in proceedings before the ECCC, which is dealing with mass crimes, by balancing the rights of civil parties with the need to a fair and expeditious trial. While the trial chamber always notes decisions issued by the pre-trial chamber with great interest, it is not bound by these decisions. 2b. The civil parties are invited to comment on the subsidiary request made by the defense that the period of detention before the military court by the accused be taken into account for any sentencing purpose, and that the accused be entitled to a reduction of any sentence in lieu of compensation for the breach of his rights. Any comment shall be made in writing within 5 days from today. Reasoning: civil parties will not normally be allowed to comment on what sentence should be imposed. The subsidiary request concerned legal issues on which their comments are invited. Next, before we start our proceedings on the facts concerning M13, according to Rule 23.7 of the Internal Rules, I would like to invite the Civil Party Lawyer Group 3 to request for the recognition of their international co-lawyer, which was not yet done during our initial hearing. Please, the national lawyer for Group 3. My name is Moch Smanari of the Civil Lawyer Group 3, and my respects to the President and Your Honors. I would like to present and to request recognition of my international co-lawyer, Mr. Philip Cannon, who is the President of the bar in France. And he was sworn in and permitted to practice his profession before the ECCC, and he abides by the laws of the government of Cambodia, and he is also recognized by the pre-trial chamber to participate in the proceedings on behalf of the Civil Parties Group 3. Therefore, I request the chamber to recognize him to participate in the proceedings, the substantive proceeding from this day onward. Thank you. The President. Mr. Philip Cannon, please stand up. Mr. Philip Cannon, the trial chamber recognize you as a lawyer representing to the Civil Party Group 3 for the purpose of the proceedings before this trial chamber. Pursuant to this recognition, you enjoy the same rights and privileges as the national lawyer. Please be seated. The President. Security guard, please bring Mr. Kaing, the accused, into the dock. The President. Next, the trial chamber would like to inform that the chamber will now have the questioning proceedings regarding the facts at M13. Before questioning the accused on the facts related to the security office M13, the trial chamber would like to inform that before the commencement of questioning on the accused related to the M13 facts, the facts committed at the security office of M13, which was responsible by the accused, is not part of the facts stated in the closing order. Because the jurisdiction of the extraordinary chambers in the courts of Cambodia is limited from the 17th April 75 to the 6th of January 1979. Secondly, the closing order reference to the facts related to Duch, to the accused, as the Deputy Secretary and later the Secretary of S21 only. However, in order to understand the context of S21 relating to the organizational structures, the operation and functioning of the S21 and other reasons, and the personality of the accused, during this hearing, it is related and necessary for the accused himself, who describes to during both the investigation phase and during his response to the opening statement by the co-prosecutors. The trial chamber would like to inform the parties that during the questioning of the facts on M13, questionings will also be raised regarding the context, the political context and historical context during that time, the consequence of his detention, his duty during the establishment of the M13, and his relevance to the Communist Party of Cambodia. The civil parties have also seen all the documents related to the fact. One is the interview of Hom En, the DC camp document, Annex 4, D59, the response of Unwarned, DC camp document, Annex 12, D59, the inter submission, the inter submission of the OCP 1925 document, the DC camp magazine, Searching for the Truth, 1983, the security system of the special zone, M13, with the ERN 0080-395 through 0080-457, and the response of the accused with the UNHCR representative, Mr. Christopher Besu. It's document D number 9. Because the proceeding is going to take quite some time, the chamber allowed Mr. Kaing to sit during the proceeding in response to the questioning raised. Before questionings on the facts, the trial chamber would like to inquire with Mr. Kaing, alias Duch. Can you describe about the establishment of the operations of the security office M13 Om Leang, Tpong, Kampong Speu province, and the M13B, which you used to work in, if you still can recall them? Can you describe the facts related to those offices to the chamber? The floor is yours.
Monsieur le Président.
Mr. Ho, Mr. President, with your leave, before the accused takes the floor, the defense would like to make some submissions with regard to the document to which you have just referred, which is the statement by Duch to the United Nations, specifically to Mr. Peshu. This statement was filed by the Office of the Co-Prosecutors. Under footnote 710 in the final submission, I note when the Office of the Co-Prosecutors refers to this statement, It indicates rightly. Statement by Kaing, alias Duch, as a suspect at HCDH ONU, which is the Human Rights Commission of the United Nations. Statement as a suspect. My learned friends of the prosecution, I am referring to your footnote number 710 of the final submission. While it is true that Duch was interviewed as a suspect, the note should have contained the information that Duch was told that he had the right to remain silent. This information does not appear in the document. This means that this statement was taken when Duch was a suspect, but he was not told that he had the right to remain silent. Most important, he was not informed that this statement would one day be included in the prosecutor's case file. Consequently, as the defense has always said, it repeats that this document should not be used against the accused. If the accused wishes to refer to the document, he has the right to do so. But on no account can the prosecution refer to the document itself. Thank you.
The President, please, the co-prosecutor, the floor is yours.
Good morning, Your Honors. Quite briefly, I hope. As this court well knows, this court is free to consider any relevant evidence, provided, among others, that such evidence is not contrary to the interest of justice. Therefore, I submit, obviously, that the declaration of the accused to the representative of the High Commissioner of Human Rights at the time is, on its face, obviously very relevant. That is the criteria. If there was any grounds that the defense thought would warrant its exclusion, if indeed the defense thought that for whatever reason this statement of the accused should not be part of the file, then it had a very clear duty, to present a motion before the co-investigative judges to have that statement withdrawn from the file. This is a very specific rule and duty as articulated by the rules. The defense did not do that. And as it has been stated, that document has been in the file since the very inception, was specifically referred to during the investigation, the defense did at the time state, when it was raised by the co-investigative judges, that it had concerns about the statement. but did not follow suit with these concerns with the appropriate action, which was a motion to have that statement taken out of the file. It is now in the file, and it is before you to consider. Again, I'm somewhat puzzled by the assertion from the defense of a right to dictate to you or the parties, and for this particular document, giving the right to the accused himself, to decide which document we may or may not consider. If it's in the file, it is open for your consideration and for debate. At least, that is how I interpret your previous rulings and the law. And let me say finally that if this document is indeed titled by us in our introductory submission as suspect statement, it is because we identified any previous statement made by Kaing Eve, aka Duch, as a suspect statement to differentiate it from witness statements, expert statements, etc. So, if I'm not mistaken, you will see, among other things, statement made by the accused to journalists referred to in our introductory submission as suspect statement. This, of course, does not in any way legally qualify the circumstances, much less the statement that was given at the time, not by judicial officers, not in the context of an arrest, not in the context of a possible prosecution by state agents, but rather a statement given freely by the accused to representative of the United Nations Human Rights Commissioner, who were acting within their mandate to gather evidence of violations of human rights. If indeed the defense can foresee any legal reasons why this statement should now, after 2 years, be withdrawn from your consideration, I would invite it so that it may assist you to make legal arguments to that effect. Thank you.
Monsieur le Président, pardonnez-moi, mais je souhaite répondre.
Mr. President, you will forgive me, but I will respond in a few words. I think my colleague did not understand what I said. I did not say that the document should be withdrawn. I just recalled that on the 21st of January 2008, we expressed the most explicit reservations before the co-investigating judges. You will see that on page 2 of the examination before the co-investigating judges of the 21st of January 2008. As my learned friends of the co-prosecutors knows, the document is indexed as D38. We expressed reservations. We did not say that the document should be withdrawn. What we said, and I maintain this, is that this cannot be used against the accused in view of the circumstances in which the document was obtained. I say that it is not normal for the United Nations human rights representative to have taken the statement without informing the person that he was considered to be a suspect, and that this statement would one day be used in the file of a prosecutor. As a human rights office, the minimum or the least one can do is to respect human rights. And we know that this document is at issue. The accused may wish to use some passages of the document as he wishes. So the document cannot be used against the accused, but the accused cannot in any way be prevented from using the document. And this is a position it has always put to the co-investigating judges and up till today.
Une question à la défense peut-être pour clarifier le...
Judge Laverne, a question to the defense to elucidate the issue with regard to this document. Does the defense consider it possible that the chamber refers to the document as a basis to examine the accused or not? Or does the defense consider that it alone has the possibility or the right to refer to the document?
Merci, Monsieur.
Mr. Hu. Thank you, Your Honor. It is the same answer that we gave to the co-investigating judges. The accused, having expressed the same reservations as I have, has agreed to answer the questions of the judges with regard to this document. So, the accused will agree to the chamber putting questions to him on the basis of this document. But the defense cannot agree that the information in this document should not be used against the accused, because the accused was not granted or read his rights at the time. That is our position.
The President, the floor is yours, the co-prosecutor.
Thank you, Mr. President, says the prosecutor. I submit that you should decide at this point whether this document can be submitted for your consideration for its incriminating and exculpatory information. So there should be a debate and a decision to ensue. Since this statement we submit contains material that could be of use to you in reaching a decision, either for incriminating or exculpatory information with regard to the crimes for which the accused has been brought before you. I fail to understand how a defense's, the accused's statement, which on the face of it contains information that could be relevant to the ascertainment of the truth and for the development of your intimate conviction, I fail to see how this material can be set aside for the purposes of your judgment by an opening statement made by one of the parties. If you cannot take account of the material, then this should be the subject of a debate and a decision. We, for our part, repeat that the contents of this statement made by the accused, until such a time as the statement is removed from the case file, should and must be taken into account for incriminating and exonerating circumstances as you judge necessary. So I would request that the chamber provide clarifications, either now or later, as to the status of this statement. If there is to be a discussion, then let it be organized either in writing or orally. Thank you.